Okay, hi, Assalamualaikum warahmatullahi wabarakatuh. We are from Group 13 and we will be presenting about right to maintenance of children and wife during marriage and after divorce. According to the Muslim law, maintenance is called nafaqah and it includes clothes, food and lodging. Muslim personal law imposes limited obligation on the husband to maintain his wife after divorce. The Muslim law imposes the liability to maintain the divorced wife only during the period of iddah and not thereafter. The Muslim Women Protection of Right on Divorce Act 1986. The act was passed to protect the rights of Muslim women who have been divorced by or have obtained a divorce from their husband. Section 72 Clause 1 of IFLA clearly specifies that it is the duty of the father to maintain his children, whether they are in his custody or the custody of other person, as it is reasonable having regards to his means and station in life or paying the cost incurred. Maintenance according to the provision includes accommodation, food, medical attention, and education. However, subsection 2 of the same provision stated that not only if the father is unable to maintain, but if he is also dead or his whereabouts are unknown, the duty shall shift to the male person liable under hukum syarak, namely the paternal grandfather and the uncles. Obviously, the duty to maintain will not transfer to the mother. Rights of a man during marriage are divorce by talaq or by order, resumption of conjugal relationship or rujuk, obedience and disobedience. And rights of a woman during marriage are mahar, ta'liq, maintenance, divorce by talaq or by order, khulu', resumption of conjugal relationship or rujuk, divorce under ta'liq or stipulation, dissolution of marriage or fasaq, presumption of death, resume cohabitation and others. Maintenance for wife during marriage includes food, clothing, lodging, and other necessary expenses for mental and physical well-being of a person. A husband is liable to provide maintenance to the wife during the marriage. This principle is drawn from the Quranic verse from Surah An-Nisa. And as for the after divorce, the woman is provided maintenance during the iddah period by her former husband. During the subsistence of marriage, while in the period of marriage, the husband is responsible to provide for his wife and children. Although the wife has a job, but alimony still needs to be given to the wife according to the ability of the husband. Refer to the Surah Al-Baqarah verse 233. Maintenance shall be given according to the one's mean, either the husband was wealthy or poor. According to the section 61 of IFLA 1984, the maintenance shall be evaluated based on the means and needs by both parties. However, according to the Shafi'i opinion, the assessment of amount of maintenance shall be based on the husband alone. Maintenance shall be continued until the death of the husband or wife. The referred cases is Zakaria versus Ahmad. Maintenance is not a gift but a right of a wife. A wife residing away from her husband on the basis of a lawful excuse is entitled to her right of maintenance. A wife who deserted her husband without any lawful reason is not entitled to past maintenance. Maintenance is to be fixed by taking into account the needs of claimants and the resources of defendants. Judges should not take the words of husband for granted in respect of their income, must not require documentary proof from wife. Maintenance for children during marriage and after divorces and other relatives. A father is responsible to maintain the children born during the marriage until they attain the age of majority in case of sons and until they are married in case of daughter, irrespective of the fact that they live away from the father with divorced mother. Father is also required to maintain a divorced or a widowed daughter. If the father is unable to provide maintenance, then the grandfather is liable to provide maintenance to his grandchildren. Under Islamic law, persons are bound to maintain their poor relative within the prohibited degrees in proportion to their share, which they will inherit from them after their death. In Islam, a father is responsible to maintain his children. It is provided in Surah Al-Baqarah verse 223, but he, the father, shall bear the cost of their food and clothing and equitable terms. And in another verse, let the man of means spend according to his means, and the man whose resources are restricted, let him spend according to what Allah has given. According to the hadith narrated by Aisyah that Hindun Binti Uqbah said, "O Rasulullah, Abu Sufyan is a stingy man. He did not give my children and me sufficient amount of maintenance unless I took it out of his knowledge." Rasulullah SAW said, "Take what is sufficient for you and your family in a good manner." There are three obligations of father in maintaining his children. The first one is relation due to marriage, relation due to lineage, and possession over a person. However, the duty to maintain is subject to certain conditions. Firstly, that the child still depends on others. As such, a father has to maintain her daughter until she marries or having a job. Secondly, that he or she does not possess any assets and is not able to maintain himself or herself. And finally, that the father has the means to maintain his children. In the case where the father is unable to maintain, the duty will transfer to the person liable under Hukum Syarak to contribute to the maintenance of the children. Child is to be maintained by the father even though the mother earns livelihood. An adopted child is to be maintained by the adopting father as a constructive guardian. The constructive guardianship creates fiduciary obligation. A mother cannot waive the maintenance right of a child by entering into an agreement with the father. A father is required to maintain his unmarried daughter even when she is earning her living. A father is to maintain unmarried adult daughter. An unmarried daughter who refuses to marry according to the wishes of her father is entitled to be maintained by him. A divorced daughter, even when living separately, is to be maintained by the father. A grandfather is liable to maintain the grandchildren if the father fails to do so. Next is quantum of maintenance. Quantum of maintenance is to be determined by taking into account the status and income of the father. Principle of res judicata, which means a matter that has been adjudicated by a competent court and may not be pursued further by the same parties, does not apply in maintenance cases. Parallel suits for the recovery of maintenance could not be filed before the arbitration council and the family court. The objective of awarding interim maintenance is to ameliorate the financial problems of minors, and it cannot be challenged in a writ petition raising new issues of fact which require a guarding of evidence.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nadhirah Binti Hashim. The issue is whether children and wife has any right to maintenance from his husband during marriage. As for wife, Section 59 Clause 1 of the Islamic Family Law Act provides that the court may, subject to Hukum Syarak, order a man to pay maintenance to his wife or former wife. According to the writers of the Islamic family law in Malaysia, this provision entitles a wife to receive maintenance during a valid subsisting marriage. A wife is entitled to maintenance upon marriage. The court may order a man to pay maintenance to his wife or former wife. For children, Section 72 Clause 1 of the Islamic Family Law Act state that except where an agreement or order of court otherwise provides, it shall be the duty of a man to maintain his children, whether they are in his custody or the custody of any other person, either by providing them with such accommodation, clothing, food, medical attention, and education as are reasonable, having regard to his means and station in life, or by paying the cost thereof. Next, the implications for not paying the maintenance to the wife. First, the court can pass arrest warrant against husband. Second, court can attach husband's property and can recover the amount from husband property. And lastly, for non-payment of maintenance ordered by the court, the husband can be sent to jail until he is able to pay up. Implications for not paying the maintenance to the child. First, be blacklisted at credit agency. Second, be jailed for a period not longer than 3 years. Third, be imprisoned with the option of paying a fine. Fourth, have interest added to their maintenance arrears. And lastly, have their property or salary attached.
My name is Nurul Nasywa Binti Rozali. Definition of maintenance. Hanafi said that maintenance is food, clothing and accommodation, and Hanbali said that maintenance is food, clothing and accommodation and their supplements. Shafi'i said that maintenance is whatever is eaten as food, clothing, cleaning tools, house appliances like cooking equipment, accommodation, and servant in the case where the wife has ever used the service of a servant before her marriage. In the case of Masrifawati Binti Humala, Marpaung vs. Mohammad Wazir bin Yobmat, a 2011 case, the wife was denied from the right of maintenance for about 9 years long, despite the fact being that the husband was in existence. As a consequence, the wife had suffered emotionally. The court had rightfully granted her FASA application and had also noted that the husband's failure to provide maintenance for his wife and had resulted in darar to the latter. Then, in the case of maintenance to a working wife, for instance, in a 2001 case of Salina binti Muhammad Dahlan against Muhammad Saleh bin Haji Harun, despite the plaintiff's occupation as a teacher, the court did not entitle her from receiving maintenance from her husband, who had denied her from such right for more than 1 year.
My name is Siti Noramanah Binti Saidi, metric number 053045. Rights to maintenance of children and wife during marriage and after divorce. Issue: whether children and wife is entitled for maintenance after divorce. According to Section 65 Clause 1 of the Islamic Family Law Federal Territory Act 1984, a right of a divorced wife to receive maintenance from her former husband under any order of court shall cease to exist on the expiry of the period of iddah or when the wife being nushuz. Implications: all maintenance are under the mother's responsibilities. If there are maintenance that the husband failed to fulfill during the marriage, the husband or former husband failed to fulfill an order for maintenance of a child of 18 years old has physical or mental disability or pursuing further or higher education or training, the process of appealing for payment of maintenance.
My name is Siti Rahmah Binti Mohammad Mahadi. My metric number is 053080. For the solutions, iddah maintenance is maintenance that is obligatory upon the man to pay to his ex-wife during the iddah period due to raj'i divorce, revocable repudiation. This maintenance includes food, clothing, and accommodation based on hukum syara. Any married woman that has been divorced are entitled for maintenance from her former husband during her iddah. The court's order will cease to end at the end of the period of iddah. The rightful maintenance are also expired if the wife is adulterous or remarried under Section 65 Clause 1 and Clause 2 of the Islamic Family Law Act 1984. Besides that, Section 82 Law Reform Marriage and Divorce Act 1976 are also mentioned. The same thing which is that an order for maintenance will expire if the wife was remarried or lived in adultery with any other person. But what if there are husbands that did not fulfill their duty as a husband during the marriage? He may not give any maintenance to his wife during the marriage. If this were to happen, the wife may claim for arrears of maintenance. Arrears of maintenance is maintenance, nafkah, which was not fulfilled by the man to his former wife during the period of their marriage and becomes a debt on the man which he is obliged to pay. These arrears may be claimed at any Sharia court. According to Section 69 of Islamic Family Law Act, arrears of maintenance can be recovered by the wife as a debt. A husband will be asked by the court to pay arrears to his former wife. If the husband died before paying the debt, then it must be paid from his property under Section 69 Clause 1. If the arrears of maintenance have not been paid before the death of the former wife, then a representative can claim it under Section 69 Clause 2. So, the wife may claim arrears maintenance from her husband if her husband did not fulfill his duty during their marriage. The maintenance will be claimed as a debt from the husband under Section 69 of Islamic Family Law Act 1984. However, what if the husband also failed to give the maintenance for their children even after the order of the court?
was given during the marriage and after the divorce. The mother may claim arrears of maintenance of the children from the court when the husband or former husband has failed to fulfill an order for maintenance of a child that has been issued by the Sharia court. The arrears can be claimed from the date of the husband's or former husband's failure to pay the order for maintenance of a child. In addition, the court may penalize whoever fails to comply with the order for the maintenance. The court may sentence a month imprisonment of each unpaid monthly payment under Section 132 of the Islamic Family Law Act. Where a husband fails to comply with the court order for maintenance, the court may levy a fine or sentence the husband to imprisonment for a maximum term of 1 month for each month's allowance that remains unpaid. Section 79 of the Islamic Family Law Act 1984 did mention that the order of maintenance of the child would be expired when the child attained the age of 18 years old. But what if the child of 18 years old was having a physical or mental disabilities, or he or she furthered their studies? Section 95 of Law Reform Act stated that the order for maintenance of a child, unless expressed to be for a shorter period or where the order has been rescinded, expires when the child reaches the age of 18 years old, unless the child has physical or mental disability or pursuing further or higher education or training. In this case, the maintenance order expires on the ceasing of the disability or on completion of education or training, whichever is later. It means that until the disability is ceased to exist or the child finish their studies or training, the maintenance will not expire even if the child age is more than 18 years old. During the process of appealing for payment of maintenance, a wife can appeal for a temporary interim maintenance. It will be in effect until the court passes the order for maintenance under Section 70. Section 70, Clause 1 of Islamic Family Law Act 1984 stated, where the court is satisfied that there are grounds for payment of maintenance, the court may make an order against the husband for payment of interim maintenance to take effect at once and to be enforced until an order of court is made on the application for maintenance. When the wife appeals against her husband for her right of maintenance, the wife may also claim for interim maintenance that will take effect immediately and be enforced while waiting for the order of the court for the application of the maintenance. Section 79 Clause 2 of the Act stated that husband may adjust the interim maintenance paid against the amount ordered to be paid for maintenance under the order of the court, provided that the amount received by the wife after any deduction is sufficient for her basic needs.
What is consolatory gift in IFLA 1984? According to the Section 2 of Islamic Family Law Act 1984, defined the consolatory gift as reasonable gift to be given to a divorced wife according to the Islamic law was called as muta'ah. Section 56 of IFLA 1984 provided that a woman who has been divorced without just cause by her husband may apply to the court for a consolatory gift. As she has been divorced without just cause, and order to husband to pay such sum as may be fair and just according to the Islamic law, the main purpose of payment consolatory is to ease the feeling of the wife who has been divorced without just cause. Muta'ah is one of the maintenance during the period of iddah or reconciliation. In Section 59, Clause 1 of Islamic Family Law Act 1984 provided that the court may order a man to pay maintenance to his former wife. In determining the amount of any maintenance that need to be paid, the court shall base it primarily on the means and needs of the parties as stated in Section 61 of IFLA 1984. In Section 85, Clause 1 of IFLA 1984 stated that the right of the divorced wife is to receive the maintenance from her former husband under any order of court shall cease on the expiry of the waiting period, that is 3 months from the divorce. There are a certain implication that may be raised if the consolatory gift was not be proceed. The first one is it can cause fellow couples to misunderstanding. The heart of the divorced wife will be hurt, causes speculation that are not easy to hear and can be viewed as slanted by society, and also relationship between ex-spouses may be severed. As a solution, since talaq is an unqualified right of a husband, its exercise is not hindered by the decree of future maintenance. Hence, in that situation, the wife may be entitled, in addition to other rights or privileges, to the payment of a parting gift or consolatory gift called muta'ah. Muta'ah is different from maintenance after divorce and is paid by a husband to his wife after divorce as a compassionate gift to lessen her difficulties caused by the divorce. The concept of muta'ah has been clearly referred to in several verses of the Al-Quran. In case of dissolution of an unconsummate marriage contracted without specific dower, only muta'ah is payable and no dower or maintenance can be claimed. However, in many Muslim countries like Egypt, Iraq, Tunisia and Turkey, muta'ah has to be paid in addition to dower and maintenance. If after the consummation of marriage, a husband pronounced talaq against the wife wishes and without any fault on her part, the husband is liable to pay muta'ah according to his financial capacity and addition to the payment of maintenance during the iddah period. The court has to determine the quantum of muta'ah by taking into account the financial status of a husband, duration of the marriage, and circumstances of divorce.
Maintenance is neither a gift nor a benefit, but an undeniable legal obligation of a husband towards his wife. The trends in case law show that the judges take a favorable approach towards a wife's right to maintenance. The courts has established that the right to maintenance during iddah period is not forfeited in case of khula. It is also well established that the mere fact that a wife is residing away from her husband does not absolve the latter of his responsibility to provide maintenance to the former, provided she has a lawful excuse to do so. The courts do not blindly favor the wife in every case, rather they tend to take a more balanced approach in maintenance cases by relieving the husband of his liability to pay maintenance in cases where the wife resides away from him without any reasonable cause. Such a wife is denied past maintenance, as the same can only be claimed by a wife who is willing to perform her marital obligations and has been deserted by her husband. The courts has established that a father is to maintain the children born during the marriage until they attain the age of majority in case of sons, and until they are married in case of daughters, irrespective of the fact that they live away from the father with the divorced mother, or that their mother earns a livelihood. Moreover, the courts have been very considerate of the financial difficulties of the divorced or widowed daughters and have given responsibility of their maintenance to their father. The judiciary has also been very progressive and thoughtful in its approach towards grant of maintenance to adopted children by resorting to the doctrine of constructive guardianship and making the adopting parents responsible for their maintenance. The development of this principle through an ingenious application of the principles of equity is a laudable step.